Live, we are live.
And now?
We are back. We're not scheduled, but taken. Great. And we have one more topic. It's exciting. Which is H206. This is the Uniform Commercial Code. Ricks, I've got you first, but you were going to, I only have you on the agenda. Yeah.
I believe the website, Recycle Office of Legislative Counsel, I'm gonna defer my time to Carl Lissman, who
Okay,
will better be able to educate the committee on the amendment.
all right, and this is an amendment, or a possible amendment.
Good afternoon. Good afternoon. It's nice to be back.
They were taller than you, huh?
Doesn't take much to be taller than, I used to be taller myself. My name is Carl Lissman. I'm a lawyer practicing in Burlington. I've been a uniform law commissioner for a long time. When I was here with you folks on the UCC bill last week, I mentioned to the chair during the presentation, there had been comment about how we as Vermonters go about doing our business without really realizing what the underpinning might be in the law for what it is that we're doing. And that sparked me to say to her that we have a relatively recent project that we've completed in 2023 called Special Deposits. And she suggested that we bring it back for your consideration. What are we talking about? We're talking about a product that a bank could offer in Vermont if this became the law. No bank would be required to do these things, but if it chose to do them, it would be helpful to the you and the me of Vermont who might get the benefit of a special deposit. So point number one is that no bank is required to do this. It would just be another arrow in its quiver of products that could offer its customers. And what is a special deposit? It's a deposit that's special. Why is it special? Because it's theoretically somebody else's money that you're putting into your account in your name. Why would you do that? Well, suppose the chair came to me and said, I trust you. I want to give you $500 to put it in an account. I want you to hold it. And on the occurrence of some event that may happen in the future, I want you to pay it out to somebody else. And if that event doesn't happen, give it back to me. There's more to it than that, but that's pretty much what we're talking about here. Problem is that there are other people who might have an interest in an account that I opened in my name, even though it wasn't my money that went into the account. One of those are my creditors. If I'm not paying my bills as they come through, a creditor can attach my bank account. I may say, wait a minute, that's not my money. You can't take that money out of that account. That's the chair's money. We don't have very good law in Vermont or anywhere in the country on that. To be clear that that money that was hers shouldn't be reachable by my creditor. And if I have a bad financial reversal and I have to file in bankruptcy, the trustee in bankruptcy may say, there's $500 in his account. We can use that to pay off his creditors. But not my money. But it's not clear. And there's a third category here, somebody who might have an interest in the money that I have in the bank account at the bank, and that's the bank. Banks have rights of set-off. If I go to the Bank of Montpelier to borrow my house and I sign a note, give the bank a mortgage, and I have a savings account at the Bank of Montpelier, and I stop making my mortgage payments, the bank technically has the right to grab whatever I have as a right to set off to pay my mortgage payment. So that's really the impetus of where this came from. The original person who suggested this was a lawyer for the Federal Reserve Bank of Cleveland who came to the Uniform Law Commission and said, we all assume. And you know what happens when you've assumed? There ought to be a law. We had a study committee that looked into it. We went to a drafting committee. A lawyer who chaired the drafting committee, a commissioner from Rhode Island, is a bank lawyer. We were very lucky to get as our reporter, the fellow who does most of the research and technical writing, had just left the Federal Reserve of New York as its general counsel to go into private practice, one of New York's most prestigious firms. This law protects money that's in a bank account in a bank that will allow this type of account by ensuring that nobody can take money out of that account unless it's the beneficiary of that account. And how do you go through that process? You walk into the bank and you say to the bank, the chair gave me $500. It's not my money. I want to put it in an account. I want to be sure that it's not accessible to my creditors. And I want to be sure that the bank will pay the money out when it's time for the beneficiary to receive it. Of course, I could be the beneficiary as well as the depositor. Complicates this a little bit, but not much. So what will happen is that the bank will have a contract form, just like it has now with a custodial account or even just a passport account. And the bank will open up the account, identifying it as a special deposit account. That account has to be signed by me as the depositor and by the bank. It has to be for a purpose that the statute says is permissible. That's in section, sorry, I don't remember these very well. Section.
On your bill,
Six.
sorry, it's 2955 in your bill, page 7, 2955.
Those purposes are specified. They're pretty objective. They're pretty obvious kinds of things that people might want to use these special deposits for. And as long as there is a written agreement signed, it's for a permitted purpose, that account will validly exist. Then the only other issue is, how does the beneficiary, the person, in this case, chair, get her hands on the money? And that is upon the occurrence of the contingency that's described in the agreement that's signed between the depositor and the bank.
And Chris talked about this, she talked about real estate agents have brokerage.
Yeah.
I make a deposit, I put it in, I pay the realtor, the broker, not necessarily the sales realtor, the salesperson, takes the deposit, it goes in the brokerage account, sits there until the day of closing or until everything falls apart, and then the deposit or a portion thereof goes back. And when you get to closing, it comes out of the brokerage account. I know attorneys have similar accounts. Is that what would be covered in here?
That's a very common example of that.
Yeah,
We assume that when you write your $1,000 check as earnest money to buy a house, that the broker deposits in the mandatory deposit account that the broker has under real estate rules, that no creditor of the broker can get their hands on that money, or the trustee in bankruptcy, or the bank. But I don't think we have any law in Vermont that says that. And that's what this law would do. It's no different than when I want to sell my business and a buyer comes to me and says, I will give you X number of dollars for your business. Let's write up a contract. It's a pretty sophisticated transaction. We might use an escrow agent, otherwise not licensed by the state of Vermont. That escrow agent might be required to put the money in an account that will earn interest. Goes into the escrow agent's account at the bank. If it's not a special deposit account, there's no law in Vermont that says that the creditors of the escrow agent can't grab that money. We just assume. And that's an assumption we shouldn't be making.
not in this day and age.
No.
The question, is it conceivable that the owner of the money may want that money to be in an account that is secreted from the general public because it's the money that they got from selling their Enron stock or what have you?
Yes, it's very possible, and that's why the standard of a permissible purpose is in here.
And how does the permissible, how is it expressed? Does it say you can't put stolen money in here or words to that effect?
It almost, a governmental, regulatory, commercial, charitable, or testamentary objective of the parties stated in the account agreement. It includes as an objective to hold funds in escrow, including for a purchase and sale, lease, buyback, or other transaction, as a security deposit for a tenant that may be distributed to a person as remuneration, retirement, or other benefit or compensation under a judgment and class action court decrees for distribution to a defined class of persons after identification of the class and their interest in the funds. Goes on and on and on. But the list here refers to this as a white list to make clear that these are all permissible purposes. If what you're talking about, if you went to the bank, said, I want to open up a special deposit, first thing the bank would ask is, what's the purpose? And they would go through the list to make sure that that was permissible. But the second thing is there has to be a contingency. There has to be an event, the occurrence or the non-occurrence of which triggers the entitlement of the beneficiary to get their hands on the money.
If the subject is indicted.
I think that probably is going to pass, but that's a good point. You can't use it to hide for an improper purpose.
I have lots of questions, but I don't think I want to ask them. Instead, I want to just ask, this is uniform commercial code. So this is adopted elsewhere. We're not creating new.
And this is not the commercial code. This is another uniform law project. It's uniform special deposits law. Thank you for saying that. I'm supposed to say to you, it's already been adopted in Washington State, Colorado, Delaware, Oklahoma, Nebraska, North Dakota, and Utah, pending in Arizona, Illinois, Massachusetts, Minnesota, New York, Rhode Island, West Virginia, and the District of Columbia. It's a new one of our newest products, so it's just started to gain some
Okay,
momentum.
so Universal Commercial Commission has, you're working on this, but it has not.
Oh, no. The Uniform Law Commission has promulgated. We are now, all of our commissioners are now going out to the legislatures in all the states and saying, here's a new law that we've got for you if you're interested.
Okay, so it's the universal, it's not part of the
It's not part of the
commercial,
commercial.
but it is part of the Universal
Of the
Law
Uniform Law
Commissions, who also does the commercial code.
Right.
It's part of your now recommendation for, so we could tinker with this,
You could.
but
You could.
shouldn't. All right.
Probably not. And may I say, it's more important to me that the commercial code 206, as it was brought to you, get enacted
Okay,
this year, even if it means pushing this off till next year.
okay.
So I'm not against this, but since it isn't part of the universal, I am going to ask some of my question. So I'm worried that some of what you said, that this would be a way to shield, to hide. If I put this money in this account, is this only going to stop the account holder, the company, the bank that has that account from using those resources if they become insolvent? But I still have to report that, right? It's not a place for me to shield assets if I were to go bankrupt.
You have,
It can't
if
be
it's not your money,
It's not your money.
then your bankruptcy estate shouldn't be able to have its hands on that money.
So if it's my money and I put it in this
No, it's
account.
not your money.
Okay.
Well, if you put the money, here's a simple example. You have $5,000 hanging around.
Me.
You.
Okay.
In $1 bills. And you think to yourself, boy, I'm a little worried about my financial condition right now. So if I can find a way to hide this money, I could dig a hole and put it in the ground in my backyard. You could put it in the backyard. Probably not a prudent thing to do. maybe I can take it to a bank and get them to put it in an account that will shield it from my creditors. You can't do that under this law.
This law would not allow.
This law would not allow that. That would not be a permissible purpose.
It
Where does
has
it
to be
say that?
somebody else's money.
It's be somebody else's money.
It's somebody else's money.
Oh,
I asked my
know
friend
that.
Scott, put my money.
In the account, it's open, there's a
But
separate.
if you didn't tell the truth when the account was open as to the purpose,
So you deposit.
could purpose be done, so generally that there isn't any specificity required. As to- I'm hiding, I'm putting the money in here in order, or my beneficiary is putting the money in here in order to ensure that it is safe, that it is protected against threats.
So, like an escrow account.
Exactly.
But that escrow account could be my money, it could be your money.
Mhm.
But the person who's opening the account is saying, this money can't be used to satisfy my creditors. Because it's not my money until the occurrence of a contingency.
Mhm.
And the bank will know what that contingency is because that'll be listed in the agreement that the depositor makes with the bank. No bank, I think no bank is ever going to say, let's allow you to do that when the purpose of the deposit is to protect your money from your creditors.
Protect the beneficiary's money, you're opening the account on behalf of the beneficiary.
The depositor can be the beneficiary as well.
Or frequently, there's more than one beneficiary. If you're a real estate brokerage or a lawyer's account, you will have multiple, hopefully, if you're a successful business, you will have multiple deposits, contract deposits on real estate you're selling. That money comes from the potential buyer. When the sales close, that money comes from the brokerage account and is written out and given to the seller. And I have to get a separate check from the broker out of his account, and that the selling agent brings to closing. But if, but my broker happens to owe his bookie a couple $1 million, the bookie can't access the brokerage account because it's not the realtor's money. It's the buyer or the seller's money. It's the buyer's money.
So in Vermont, the real estate commission says to licensed brokers and salespeople, you have to have an account in which you deposit deposits. The rules of the Supreme Court tell us that for lawyers, you have to have a separate account in which you have client trust funds. Still, there's no law right now that says that my creditors can't go to my IOLTA trust account and try to grab that money, claiming that it's money that I have. Now, I'm not allowed to put money in my IOLTA trust account by rule of the Supreme Court. This will clarify, not only for lawyers and accountants, but for every other transaction where somebody is entrusted with somebody else's money. That money is protected from the creditors of the person who made the deposit. It's a simple little law.
I think we've gotten the questions as to what the law does. I think we may have some questions about should we do it or where is it? And I'm going to get to our legal counsel for that one.
Good afternoon. Rick Sagel, Office of Legislative Counsel, and just a little bit, I think it's clearer than it was maybe right away, but this is an amendment to 206, the UCC bill, Uniform Commercial Code bill, which is fairly straightforward. We've had the UCC for several decades now. We've amended the UCC several times in the last 20, 30 years. 2015 was the last major amendment. So this amendment, the Uniform Special Deposits Act, is not the UCC, but it's from the same ULC, the same entity that comes up with these model laws. They have several of these that they produce for state legislatures to consider. Vermont has several other ones that they've adopted. So this one, the Uniform Special Deposit Act is newer, as Carl talked about. I think 7 states have passed it. I think it was promulgated in 2023, so it's begun to roll out to various states. I think Carl explained it well. I have a few concerns about it. Mostly that it is so new, and that you haven't taken testimony over it. With the UCC, I was confident that, you know, this is not a controversial amendment we're talking about. And not that this is controversial either, to make that clear, but because I haven't had time to fully vet it. Maria Royal, who is more our legal counsel for banking, she's had a little bit of time, but not enough time to vet it. So my recommendation is, if you want to take it up, it's your, obviously, your call. I would recommend testimony. I would recommend a further deep dive into, do we have Vermont laws that may conflict with this? I don't think we do. But again, I didn't have time to fully make sure, do we have something?
Okay.
I know we don't have something that does this. I know that much. We don't, as Carl said, we don't have laws that protect these special deposits. And I don't think that you have the hidden money. I'm sure the ULC was aware of that, talking about a person that's trying to hide money from creditors. That's not what this bill does. The bill is meant to protect consumers, protect your money, so that if you give your realtor, or if you give the $1,000 in escrow for your house, or you're a tenant, and you put your deposit of $2,000 down for your apartment, that is your money technically, but it's in the landlord's account. The landlord goes bankrupt. That money, yes, could be taken by a creditor, right? This law, and it's also opt-in. So even if this law were enacted, the bank and the depositor would still have to agree that this is a special deposit. The tenant may not even know that that is a protected deposit, right?
Right.
So I think maybe the bill would also suggest maybe some literature that would be required to produce by tenants or by banks that, hey, this money is under a special deposit. These are things I'm thinking about that.
Yeah, right now, as a tenant, I wouldn't know. I've got quite a few $1,000 in security deposits down. My landlord owes his bookie. He's got a gambling problem. I could find, I'm saying, well, you know, I'm gonna stay here for a year. And then, you know, I'm gonna get a promotion. I'm gonna move next door up to a nicer apartment. I know right where I want to go. And I'm gonna use my security deposit on this apartment. I'm just gonna transfer it over to that one.
Right.
Only the bookie comes in and takes all the money. I wouldn't right now. That money, I have no guarantee, right? That money's gonna be there. The owner can go bankrupt. The owner can spend it.
Yeah. And the tenant has a right for the money. They can sue the landlord.
They can
If
sue it.
the landlord's bankrupt, then there is, I see the legitimate purpose behind the bill, and I see why states are adopting it. I don't see any harm, but I think it'd be a disservice not to take more testimony over it.
Yeah,
Oh,
the bankers.
I mean, the question comes up, how does the person who is owed money by the beneficiary of this account even know the account exists and the money is there? In the event, for example, that he brought an action against that beneficiary to collect money,
The creditor
Yeah.
or the beneficiary of the account?
the beneficiary of the account.
Well, so currently it's still an issue, right? If you're a tenant, or if you are buying a house and you give the money to the real estate agent, or however it's done in this state, you trust that money is protected, right? But it's not. So today, there's no formal requirement that you tell the potential home buyer or the tenant that this money is in a safe account. This bill,
Well, this is way, it seems this would establish really protections from that.
yes,
But so when the person who has the security deposit there, that they can't get back, that the individual that they gave it to is the one who sets up the account.
Right.
And that person has gone to Luxembourg
right.
in order to avoid arrest. How does that person who is the ultimate payer who is owed the money even know that this account exists or knows it's a place where his money is hiding?
It's a good question. So that might be something I'll defer to Carl on it, there's a mechanism for that, but I do think that we might need an education piece for that,
I mean, if the person who has fled has put the money someplace, it may be traceable, but here where you've done private deal with an attorney or whoever to put the money into this particular account that can only be released under certain circumstances to the beneficiary, how does anybody who has a valid claim know that it exists and know that it's a place to even hunt for it?
I think I'm getting the message that we have questions and that this may not be ready for prime time. We have 7 other states we can ask, it doesn't have to be done now. We've been doing.
And one other question I basically had is, we know that some is done. Do you know whether it's been presented to any other state that's declined to take it up?
Not sure if it's been declined, but it's currently, like it is in Vermont, under consideration. That's the term.
And we have another year in this biennium. And so we can always find something to attach something to. Their tax in this, it's a bank tax, so we're not getting a miscellaneous tax this year. Everything the tax department wanted is riding in the education bill. Of course, if that doesn't make it, we might get a miscellaneous tax bill. And we'll have to do some shenanigans on, maybe that's how we'll use the agriculture bill. We're gonna be in. But worse things have been done.
Another question.
Yeah, I think what I'm hearing is I'm gonna let this sit. Well, I hope vote the UCC out tomorrow and then we can let this one ride and take some time and talk, see what other states have done. See if they've encountered any difficulties that we can learn from, or we'll probably give Rick and Maria time to research.
And there may be easy answers to all the questions I've asked. Somebody else's elbow is just, I just don't know.
It's a good question.
Yeah, and we probably just need time to do a list of questions. We can let this bill sit for a week. We can see if we can come up with a list of questions. Just everybody, if you have them, we'll take a few minutes at the end of the day tomorrow when we're all happy and fresh. And see if we can come up with some questions that we might need. And Rick, you can help us with questions you would like. And can you communicate to Maria, or do we need to send her an email? Or maybe we'll see if Maria can join us.
She's out of town.
She's out of town.
She'll be back on next week.
Okay, so we won't have her. So we will put this off till next week, because she does do most of our banking.
And she's aware of the bill, but
Okay.
it's
This is
also,
new, and we should hear from our council that does banking, if we're talking about banking. And we'll give the bankers a chance to think on it. And if we think we might go forward with this, bill doesn't have to come out tomorrow. It can come out. I told the office I would either not bring it up until tomorrow, or we wouldn't vote it until tomorrow, so that they could close the calendar and go home before 7, 8 o'clock. And we will take this up again. That'll give everybody some time. In the meantime, Carl, if you just have like one sentence, as 2, 3, as to what's covered in each section of that bill. Because we didn't go into a lot of detail, but I'm gonna have to tell them something on the floor.
I will get that for you.
Okay, thank you.
Thank you.
That, yes, we know we can't change it or alter it. We know we need to pass it, but we should know what it is. Okay, I think that's it.